Good afternoon. Thank you for joining us for Protecting Your Passion, Essential IP Strategies. I'm Cheryl Darrop, Chief Strategist of Qti.ai. We will hear from 4 panelists in the next hour or so, with plenty of time for Q&A at the end. So please drop any questions in the Q&A box. Jennifer Cook is a remarkably talented artist who is a client of both Qti and RightsClick. Steve, Tepp, and David Newhoff have manifested their longtime advocacy for independent creative professionals into a very useful platform called RightsClick. And Will Boychuck is the heart and soul behind Qti, a brand protection agency dedicated to defending the intellectual property rights of small businesses like SnakeArts. So, Jennifer, take it away.
Hello, everyone. As Cheryl said, my name is Jennifer Cook, and my company is SnakeArts.com. I graduated from art school in the early 90s and was fortunate enough to jump straight into many artists' dream job as a commercial artist working in the field of sculpture for prototypes for the giftware and toy industries. My work was to transform the needs of the various clients that we had. Most of the intellectual property heavy hitters, Disney, Warner Brothers, Lucasfilms, all companies that were large and very protective of their intellectual property. As I was coming up through high school and through art school, there was almost a fear factor from these companies, because Disney in particular was known that if a daycare center had painted Mickey Mouse on the side, they would actually litigate and force the daycare company to remove their intellectual property from the side of the daycare company. Over a span of 20 plus years, I evolved and began creating my own work. And that led me to do some amazing commissioned work for a variety of clients, mostly involving reptiles. I did work for the Chiricahua Desert Museum, for the Paris Natural History Museum, and I got to know the people who are passionate about these animals, and I got to learn more about the animals and which ones would bite. Then as my work gained popularity and more people kept asking me to do work for them, I had an online presence, and I moved my social media and my portfolio website into an e-commerce sphere in order to try and monetize my work. And that very quickly realized how little I knew about copyright. Within hours of me switching from a portfolio site to an e-commerce site, my website was scraped, and all of my images and description and pricing information was then used for fraudulent ads on social media. My website was cloned, and my nightmare began. And I realized yesterday that it was 3 years ago this week that this happened. So I have been fighting this fight and learning for the last 3 years. I came into the online sphere with social media, the whole, like, repost, and it felt safe to post my work and to ask questions and to engage, and really didn't understand the vulnerabilities of having an online presence that way. And when these scams hit, I realized just how little I knew about copyright law, and I needed to learn very, very quickly. So I began searching and reporting and issuing DMCA takedowns and trying to find other avenues for this to stop. And I became part of online communities and scam busting websites and scam busting groups online to try and figure out if there was a solution for this. And then the nightmare got worse as I was successful in taking down my images from these websites and getting the website stopped. The people who had purchased from these websites then found me and claimed that I had scammed them. And it was harmful to my reputation. It was harmful to my business. It was harmful to my rights of authorship for these works, because suddenly my photos were used for mass market goods coming out of China and India. And it became very confusing and very difficult. It has cost me the ability to monetize my work. It has damaged my reputation and my rights of authorship. I quickly found that each website had a different form, whether it was an individual website. In many cases, the owner and host had been hidden. And then in many cases, the larger platforms like Alibaba had their own form that I had to populate, and the information and functionality of the form changed depending on the browser that you were using. As I interacted with the scam busting groups, I found more artists who were having these issues, and there was just a great deal of confusion as to how to proceed and how to protect my work. And then I also realized that I could not enforce my copyright without an actual registration with the US Copyright Office. When I went through art school, what I had learned in the tiny little survey course was that copyright was established once the work was in fixed and tangible form, and that I own that copyright. But I quickly realized that I could not sue to enforce my rights unless I registered, which was quite eye-opening for me. The Copyright Office website is old and difficult to use, and I had issues with that. And it's also browser dependent as far as getting the application to go through. And there's a lot of legal lingo that, unless you have a lawyer to ask, it's hard to determine what needs to go and which box needs to be checked. Then through my struggle to register my copyrights and to enforce my copyrights and to find the infringers and to try and seek legal action, I was looking for a solution, and I found Qti, and then I found RightsClick. And Qti was able to find the infringers far faster than I could, and find the domain hosts far faster than I could. And it also put a layer of protection between me and the infringers, because I had also found that when I was protecting my IP and filling out these forms, that was enough information that the scammers who had stolen my images used that to send out more scams. And I was signed up for dating sites and for porn sites and for email scams and phishing. And it became a nightmare. And we had to lock down our credit and change our bank accounts and change our passwords just to protect what we had, not just my IP. That led to further online harassment on social media and on my website and through web pages as well. So Qti is essentially put up a wall for me. And now these scammers deal with Qti, and I don't have to spend hours a day searching to find the infringements and to have them taken down. It's been incredibly helpful because I felt very alone and very much over my head without understanding everything that had gone on. And I had spent my life concentrating on making great art, not on the legal side of things or on web development or the nefarious practices of scammers. So it has been a great comfort to have both Qti and RightsClick to be able to help guide and give support. I didn't understand nearly as much as I thought I did, even after working 20 years in the industry. And there were just things that I didn't know. And in order to elaborate on the other things that artists don't know about copyright and intellectual property, I'm going to hand this off to Steve from RightsClick to explain more.
Thank you very much, Jennifer. Thank you for sharing that story with us. It's the challenges are incredible, and so many independent creators and small businesses face them. But thank you for your courage to take on the scammers, and for your determination to see your way through to finding the way to vindicate your rights. What I want to talk about as an introduction to the rest of the webinar is how small businesses and independent creators can take control of their rights. The scammers depend on you being intimidated by the legal system, being intimidated by the complexities, and giving up. Because there are really strong tools out there, but you do have to have some ability to gain access to them. We want to help point you in that direction so that you have that ability. So let's begin with a very quick overview of the major forms of intellectual property, just to distinguish them very quickly. You see here this form with the seal on it. It says United States of America. That's a patent. That's what you get when the U.S. Patent and Trademark Office, you see their logo, issues a patent. You have to apply to them, tell them what your invention is. Patents cover inventions, usually with a utilitarian function. They have to be new. And the protection lasts 20 years from the time you file your application. And it takes them a few years to examine, so you're probably going to get 16 or 17 years of actual protection. If you don't have that form with the seal on it, you don't have a patent. It's that simple. And that's really all we're going to talk about today about patents, because it's a very specialized area of law. But every small business has a trademark. They have a brand, they have a name, they probably have a logo. Many of their products may have logos. That is the subject of trademark. And I'm sure everyone has seen the little TM next to a name, or the R in a circle for registered trademark. Again, those are issued by the U.S. Patent and Trademark Office. You have to be using them in commerce. The protection lasts as long as you're still using them. And almost anything can be a trademark. The name, even things like sounds and scents can be trademarks. The sound of Harley Davidson motorcycles is a very famous sound mark. And then we have copyright, which is administered by the Copyright Office. You see their logo there. That's a separate office from the Patent and Trademark Office. And copyright protects creative expression, as Jennifer said, fixed in a tangible medium. Not just, you can't just say, oh, I have an idea for a story. That's not enough. You've got to have written something down. In the old days, we would say written it on paper. Now, of course, everyone's using computers for whether it's design, photographs. The instant you take that photograph, now you have a copyrightable work. The copyright lasts for a really long time, but the life of the author plus another 70 years. But there are also a lot of exceptions to copyright law. And one of the catches in the system, as Jennifer mentioned, is that while technically the copyright exists, as an American author, you can't go to court to enforce your rights unless and until you've registered with the U.S. Copyright Office. You can register anytime during the life of the copyright. So even after you're gone, your heirs could register the copyright if you didn't. But another catch. There are certain remedies that you get only if you've registered before the infringement starts. And they're really powerful remedies. One of them is called statutory damages, which means instead of having to prove how much harm there was, you can just say to the court, whether it's the judge or the jury, you just pick an amount from the range in the statute. And what is that range? It's up to $30,000 per infringed work for even garden variety infringements. And if you can show that the infringement was willful, that they knew they were infringing and did it anyway, it can go as high as $150,000 for each work infringed. Somebody copied 10 of your images, that's $1.5 million maximum award. Now, a lot of people say, look, that's all well and good. I'm never going to go to court. It's expensive. It's time consuming. Well, if you have a US copyright registration, it helps you in a myriad of ways. You're showing anybody who's used your work without permission that you know what you need to do, that you're in control. This is what we mean about taking control of your rights. Even if you're just sending a letter to someone saying, hey, you used my work without permission, stop. If you can cite to that registration, your request carries a lot more oomph. And even with some foreign actors, I see there's a question in the chat, we'll get to that a little bit more, about dealing with foreign-based infringements. It doesn't have the force of law outside the United States, but it has credibility. And a lot of these are really just boiled down to negotiations and essentially playing poker with the infringer. It's a bluff. You don't want to go to court. They don't want to go to court. If you show that you've got a strong hand, like having a registration certificate is like showing a pair of aces up in poker. You're just showing a strong hand, and everything's easier from there. RightsClick and Qti were designed to help you get control of your rights and enforce your rights. Registration is the entry to the system for managing and enforcing your copyright rights. And so now I'm going to turn to co-founder of RightsClick, David Newhoff, to tell you more about how RightsClick works and how simple and easy it makes copyright registration.
Thank you, Steve. Thank you, everyone, for joining today. As Steve just mentioned, RightsClick and Qti are both designed to help creators like Jennifer make managing this stuff a lot easier, safer, faster, all of the above. And so one of the things Steve just mentioned is the importance of registration of work before it leaves. We say this over and over again. Try to register your work before it goes anywhere. That way, it has no chance of having been infringed prior to the registration being sent into the Copyright Office. So as an example, as you see, this sculptural work is not truly a sculptural work, but I'm using it as a representation of something that in many cases, like, for example, Jennifer's business, there are likely to be two different types of works worth protecting. And I'll show you real quickly how we do that through RightsClick. But here we have a sculptural work, and that in and of itself is protectable under the Copyright Act. And also you may have photographs that are product photos that you use for advertising and marketing the work. Those photographs are also separately protectable under the Copyright Act, and they would be registered in two different ways, both of which we handle through RightsClick. So in the next slide, for example, you'll see that here's what we would do with a sculptural work. You would, first and foremost, we recommend to most people that if you have a three-dimensional work, even sometimes a painting, it's a good idea to photograph that work from multiple angles. So one good news is that if, let's say, you are registering jewelry or a sculpture or something of that, or even a painting of which there's one of a kind, you don't need to send that into the Copyright Office. You don't need to send them a copy of your sculpture. You can send photographs of the work to represent that work. It's called the deposit copy. However, in this case, we recommend taking images of it from different angles so that the examiner at the Copyright Office can see all the different expression within that the work contains. And then, for example, in RightsClick, you would give the project a name, tell it the type of work it is. Here it's a sculpture, and you'll see that we have this radio button that says, do you want us to treat these separate images as one work? And in this case, you would, because you're just registering one sculpture. There you build a portfolio of projects within RightsClick, These we then submit to the Copyright Office. And in the next slide, you'll see that, for example, in the frame on the left there, you see that that column says requested, meaning that that has been sent through to RightsClick. RightsClick processes with the Copyright Office. We deal with the Copyright Office for you. And then on the frame on the right, you see that the application date and a case number, in this case, a fake case number, has been added to that field. That gets automatically assigned to your project, so that once it's processed with the Copyright Office, what they do is they assign a case number while they take the time, could be several weeks, to actually grant the certificate and then send a registration number. But that case number is how they track the entire application through the process. And also that date is really important. The date you apply for a copyright registration is called the effective date of registration. So you heard Steve mention that you want for example, a copyright registration to have occurred prior to discovery of an infringement. So what happens if you send an application on Monday and by Tuesday your work is infringed? Good news is, if you actually had to go to court on that, the court would require that you come in with the registration certificate before you proceed. However, the effective date is the date you applied. And so that date is really, really, really important in that terms. Separately, I mentioned the photograph. So on the next slide, let's say you have product photos of the same product that you're putting out on, on e-commerce and or your own website or both. Those photographs could also be registered individually, and we'll talk in a moment how that plays into the Qti system. But so, for example, I would create a project here. You see that it's type photograph instead of type sculpture, and I can upload all the photographs related to this project and separately send that as a group of photographs. Another thing to note about photographs that's unique to other types of works, the Copyright Office allows up to 750 photographs registered on a single application. So one way you can use that to your advantage if you're running a business is, say, let's say you've got 3 or 4 products, each of them has 50 product shots that you want to register. You can actually group those all into one registration with the Copyright Office. You don't have to separate them by kind of creatively, if you will. The only distinction is that a group has to either be all published or all unpublished. You can't mix the two together. And on the next slide, I'll just recap that, as mentioned, we say it again and again and again, register work before it's distributed or shared with anyone. That way you know it's fully protected. I mentioned publication a moment ago. This is a big question in copyright law, is exactly what does it mean to have published a work? One advantage to registering before you send it anywhere is you don't need to worry about that. If it hasn't left your studio, it hasn't been published for sure. Yes, we answer that question on a regular basis. Your attorney will answer that question. It comes up a lot, but you don't have to worry about it. If you've got work that you haven't let out in the world yet, it is not published. Build registration into a budget. The cost of an application is not that high. A given application is going to be under $100. Most budgets can tolerate that additional line. What we often find is that when creators think about it and know that they're going to do it and build it into the workflow, if it's part of the budget, it's not a surprise. It's when it's an afterthought. It's that, oh, that's an extra expense. It's a different way to think about it. And when you do register and get that certificate from the Copyright Office, do keep it in a safe place. If you did ever have to go to court, one of the first things your attorney is going to say is, where's the original certificate, not a photocopy of it? And you do want to be able to produce that from your file somewhere. So more questions answered on rightsclick.com, but I'll now, with that, turn it over to Will, who will talk a bit about what Qti does and how it addresses some of these issues.
Hey everyone, thank you David for that. RightsClick is an amazing platform. And really, when I like to think about tackling the infringement problem, I tend to think about it in three separate columns. The first column being registration and essentially getting your IP in order. The second column, which I'll talk a little bit more about with the Qti's aspect, is being able to detect and identify infringement. And then the third column being, well, what happens if you request removals and removals don't actually occur, and getting more into the legal aspect. So those are the three main columns. Like Cheryl said at the very beginning, my name's Will Boychuck, and Qti is essentially a company that's based around being able to help small businesses and independent artists protect their brand for an affordable and reasonable rate, and different strategies that we employ in order to make that happen. I'm going to be going into today. So the first thing really is just different ways to identify image infringement. Images are obviously everywhere on the internet, and usually they're the primary way that we're able to identify where some of our works are being used. So if you have a product that's may not be protected by copyright, but maybe a patent, you still have product images, you have images of that product. If you have a book, you'll have a picture of the cover. If you have artwork, obviously the work of art is an image. So that's our primary way of being able to scan and identify infringements. Right now, there are free to use tools. There's plenty of resources online in order to go out and actually identify and see where your works are being infringed. Some of those include Google Lens. Previously, it was known as Google Reverse Image Search. That's great because it's pretty broad. Google, obviously, they scrape the internet, and they have a way of documenting and prioritizing different web pages. So it's broad. If you want to know where your images are appearing online, you can use Google Reverse Image Search Engine or Google Lens. More specifically, some marketplaces are coming out with particular image reverse search engines for their own platforms. So for example, Amazon, if you take a picture, they have something very similar to Google Lens, except now instead of searching the entire internet, now you're just looking at Amazon's catalog. Alibaba is also coming up with another very similar reverse image search engine, essentially, to be able to go out and identify products from their catalog. Primarily, we use images, and that's a great way to start, but there's also text-based indicators that we call in order to find infringements on different platforms. So being able to figure out what keywords are being used in infringements of your work, that's really important. And then also being able to identify keywords or key attributes within URLs. That's also important. Now, all of this will be able to be compiled and is useful in the hunt for infringements. And what the beauty about the Qti.ai software is that it takes all of these different strategies and sort of compiles it into one solid software where we can go out and we can take images into account, we can take text into account, we can take descriptions, titles, prices, all of that into account and essentially build a profile for a particular set of infringements. And then we can go out and we can look for images and other listings that match those indicators from the profile. And I'll give an example using one of Jennifer Cook's beautiful pieces of art, the famous rattlesnake door handles. So we can start off with this. We can start off with just one image. Very, very easy, very simple. And this particular image was actually taken by Jennifer Cook. What we can do is we can run this through some of those free to use tools. Obviously through the Qti software, we're able to sort of do that automatically. And we also have tools that we use in order to go out and find infringements. But if we do that, what we're going to do is we're going to find listings that have other similar images. We'll find listings with counterfeits, and they're promoting counterfeits, but the images are similar enough that it's going to recognize in a reverse image search request. We'll find other images also taken by Jennifer Cook, maybe of a different angle. And then finally, we'll see images that are modified in some way. Typically, scammers, either they might crop the image, they may include other images to try and evade sort of this standard detection by looking at just an identical image match. And now what we can do is, in this example, now we have 3 more images, and we can do this in a recursive way. So what that's going to allow us to do is then plug each one of these images through and do an independent search. And then that's going to possibly find 3 more listings or 10 more listings or 50 more listings. And while we're doing this sort of recursive search, we're collecting hundreds or thousands or tens of thousands of more images, hundreds of more listings, and then building a sort of better mousetrap or a better a profile for the brand in order to go and find even more infringement. Now, images aren't the only things that we do. As I mentioned before, there are different text-based indicators that we can use. So for example, on the left here, we have an image of an eBay listing that is selling counterfeits of Jennifer Cook's sculptures. We can take a look at the text and the title of that, and we can use that text and plug it into a regular search engine, or again, go back and look at other listings that we've previously found using the Qti system, and be able to see if there's any matches and see if we can, go back and find additional infringement. On the right side, we have an Etsy listing of, again, someone selling counterfeit or infringing products from the SnakeArts brand. If we look at the URL of this, we can see that there are keywords also being used, for example, vintage snake shaped cast iron door. So now what we can do is we can go and look for URLs with that same sort of makeup, or the URL, has to include these particular words in order to be viable, which we can then pass through the system and then scan each listing individually for possibly infringing images. So this is essentially a broad overview of how we go and we find infringement. The next thing that I'll talk about is strategies on how to actually remove listings. What is great about Qti as a company, and just based on really how the company is formed, is that we have relationships with a lot of wholesaling websites, for example, Alibaba and its affiliates. And what's great about that is the fact that we can represent our clients, or we are representatives on behalf of our clients. That means that if Jennifer Cook wants to remove these infringing listings from 1688, for example, which is an Alibaba affiliate, if she went as an individual, she would have to submit her driver's license, her passport information, all that stuff. If we are her authorized representative, all we have to do is we have to submit a document saying Jennifer Cook approves that we are her authorized representative in order to handle this for her. You can use all of our documentation in order to prove that we are a legitimate entity, which is great because it really masks some possible dangers that Jennifer may have when providing her personal information to a Chinese marketplace. But we focus on the Chinese marketplaces, and we start there because that is where a lot of the wholesale of counterfeit or infringing items start. So we can see, if you are, for example, a drop shipper, you may unknowingly be purchasing and peddling counterfeit goods. If I am an Amazon seller and I want to make a quick buck, I go to Alibaba, AliExpress, find cheap goods, some of which may be infringing, and then post it on my Amazon store and then do drop shipping. And drop shipping, for those who don't know, is essentially a process where me as a seller, I never actually hold the items in my hand. What I do is whenever I get a purchase from Amazon, I go to Alibaba and make that purchase and then send it directly to whoever purchased it from my Amazon storefront. We see this as a very common strategy for a lot of infringing goods for our clients. So what we do is we focus on Alibaba, we focus on the wholesale websites. Once we get those listings down, what we begin to see is the drop off of some of these more consumer-based marketplaces or listings. So if we can move on to the next portion here, there's going to be these Etsy, or there's the Etsy listing, there's an eBay listing. And once we start to remove the AliExpress and Alibaba listings, we're going to see those listings start to drop off. And that's really the power of, going into this with a strategy where you may see your products on eBay or Amazon or Etsy, but that's not really where it begins. If you see them on those marketplaces, it's likely that there's wholesaling occurring on the Chinese marketplaces, and being able to tackle those first is a really strong strategy in order to remove these counterfeit goods. Next we're going to talk a little bit about some of the DMCA and some of the basics of the DMCA. This is a really great process for all people, even without a registered copyright, to be able to request the removal of infringing products or infringing images from websites. So I'll hand that over to Steve for him to go into a little bit more detail.
Thanks very much, Will. So yeah, the DMCA is a law that was passed by Congress in 1998, and it's a complicated law. I'm not going to get into every detail of it. What's relevant here is the law created a process for copyright owners to send a notice to the operators of internet platforms. The typical situation is like a YouTube or a social media site, any place where the platform is hosting third-party content, because inevitably somebody's going to post copyrighted works to which they don't have the rights. And so the idea is, instead of having to go to court to deal with that, the copyright owner can just send a notice to the operator of the website saying, hey, I'm the copyright owner of such and such a work, and it's being infringed on your site. Here's where it's being infringed. I have a good faith belief it's not authorized. I'm the copyright owner, or authorized by the copyright owner to send the notice. Here's where you can reach me, and your e-signature. And the website should take it down. I can't promise they always will, particularly if they're foreign websites. US law doesn't cover foreign websites operating entirely outside the United States. And it's possible for the work to be taken down and then it gets put right back up. The DMCA is not a perfect tool, but it's very quick and easy. It literally takes a minute to do this. RightsClick has a tool that will help you do that very quickly. And you can see this information is all available on the RightsClick website, so you don't have to worry about memorizing it right now. So Cheryl, I've been trying to keep up with the Q&A in the chat, and in at least one case, I think I did not satisfy someone who asked a question, so I apologize. If they want to try again, happy to do that.
Great, thank you, Steve. We did get a couple of questions privately, and this one I believe is probably for QTI. Have you brought any cases through to litigation?
Yeah, that's a great question. So again, some of the power of QTI and why it's, okay, I might be a little bit biased, but why it's so great is because we are able to document the infringement process throughout the entire thing. So we can, for example, we know how we found a particular listing. We know what that listing contained. We take screenshots of the listing. We can keep track of the price. We can keep track of all this information. And even if we go and then we have all this information, we have it recorded, we go and then on our client's behalf, we request a removal. And even if that removal is successful, and especially if that removal is not successful, we have all this evidentiary data that we can then go and we can essentially bring a case against some of the scammers, some of the counterfeiters that have infringed upon our clients' rights. And we've done this with many of our clients where they use our information and the data that we've collected to go out and to litigate and to freeze accounts, freeze assets, and then have sort of a recovery. And it's successful, and we're able to do this in a way where it's cost effective. We work with a lot of law firms that work on a contingency basis, so no one gets paid until everybody gets paid. And it's great because it keeps the cost of entry low, and for a majority of the cases, it's relatively quick. Because we can ask for injunctions and restraining orders to prevent some of these scammers from having access to the funds that they've collected on infringing goods. And if you want to, settle out of court very quickly, a good strategy is to freeze the assets of an alleged infringer.
Thank you, Will. Another question that came in is probably for Stephen or David. Can you give us broad examples of content that is not copyrightable?
I'm happy to take that one, David, unless you want it. Okay. So in order to be copyrightable, the law and even the Supreme Court has said there must be a modicum, a very small amount, at least, of creative expression fixed in a tangible medium. If you just have an idea in your head about a great story or a great design, or I can imagine wonderful designs. I could never create when I don't have the talent. I am envious of talented artists like Jennifer. In terms of the substance of what is fixed that is not copyrightable, facts are not copyrightable. It's 83 degrees. It's a fact, not copyrightable. Individual words, short phrases, titles, all per se, meaning automatically, not copyrightable. It gets into some gray area when you deal with something that is applied art, where you have a functional aspect and a creative aspect, because the Copyright Office won't consider the functional aspects because they're dictated by the function. So there's no room for creativity. But as general statement, those are some guideposts to what is or is not the basic threshold for copyrightability.
Great. Thank you, Steve.
That Jennifer's door handles are a perfect example of that. The elements that make them function as door handles, not protectable under copyright. The design elements, however, are protectable under copyright.
Yeah, fascinating. Thank you. Another question, probably for the RightsClick crowd. What are some factors of fair use?
Uh-oh, that's probably me again. Sorry. So just for a little bit of background, fair use is what's called an affirmative defense to copyright infringement. What that means is, first you have to, if you're going to court to sue someone for infringement, the first thing you have to do is prove that they're infringing one of the rights that you have in the law. That begins with basic things like proving you're the copyright owner, proving the work is copyrightable. Good news, the copyright registration that you have to have in order to go to court is a presumption that all the facts in the certificate are true. So it's a presumption that the work is copyrightable, because if the Copyright Office didn't think so, they wouldn't issue it. And if you put yourself as the author and copyright owner, then the court just assumes that's true. You don't have to prove it. It's up to the other side to disprove it if they want to try. Then you show that they copied your work. If it's a photograph, for example, it's probably the entire thing, and boom, it's exactly the same, open and shut case. Now they're going to turn around and say, but wait, it's okay because it's fair use. And in order to prove that, it's on the defendant to prove that. They have to show that the 4 factors of fair use in balance favor them over your infringement claim. The 4 factors are the nature of the use. So if it's a commercial use, that's generally going to weigh in favor of finding infringement. If it's a non-commercial use for something like education or comment and criticism, news reporting, that's going to favor a finding of fair use. Second is the nature of the copyrighted work. Is it a very creative work, or is it, like a scientific paper with a lot of facts in it? As we said, facts are not copyrightable. So The more creative the underlying work is, the stronger the copyright protection, the more likely it's a finding of infringement, not fair use. Third is the amount and substantiality of the portion used. How much did they copy? Again, if it's a photograph, if it's a graphic design, they copied the whole thing, pretty open and shut. That favors a finding of infringement. But what if you wrote a novel that's 600 pages long and they copied 2 sentences? That's probably more likely to favor fair use, although it's not just a question of percentage, it's also the qualitative aspect. Did they copy the heart of the work? Courts will consider that as well. Finally, and perhaps most importantly, the harm to the market or the potential market for the work. So in Jennifer's case, she had a business selling her sculptures. And all of a sudden, people copied her sculptures without permission, and they started selling the copies. That deprived Jennifer of customers. That's harm to the market for the work. That's about as clear a case of harm as you're going to find. That clearly favors a finding of infringement. Or you could imagine somebody took a product image of one of Jennifer's sculptures and put it on a t-shirt or a hat or something. Maybe that's not something Jennifer had done before, but it is a potential market for the work. She could license that and get paid by the manufacturer of those t-shirts and hats, whatever. And so someone doing that without permission is harming the potential market for the work, again, favoring a finding of infringement. Fair use is very hard to predict because it's not just added up and 3 beats 1. The court will weigh if one factor seems much more important than the others, 1 could beat 3. Most of the time, it's pretty obvious who's going to win, particularly in a commercial infringement case, but not always. There are lots of close calls, and fair use is notoriously difficult to predict. That said, we've built a unique tool in RightsClick, our infringement assessment tool. We prompt you with just a few questions about the type of use that you discovered. Somebody used your work without permission, and you want to know how strong is your case. Answer those questions in the RightsClick assessment tool, including some basic questions that go to this fair use issue, and you'll get a report that will help you make a decision about the strength of your claim and how you want to proceed.
Fantastic. Thank you. We did have a question from here, Richard Philbrick. What options are available when a DMCA notice is declined? So for example, Meta, Facebook, Instagram reply to a DMCA with the item appears to be different, even if it isn't true. I understand that if they are to keep their safe harbor status, they must comply in a timely manner.
I'd actually like to address that briefly. Yes, if they apply in a timely manner, they will maintain their safe harbor status. In the case of Meta and Facebook and Instagram, that has been an issue that I have had. The infringements that I found occurred just over 3 years ago, and I issued DMCA on that content. And in almost every case, that content is still available on Facebook. And I am currently litigating against Facebook for refusing to take down the content. And the court has taken away their safe harbor, and they must answer my lawsuit. And in that case as well, I have found that you apply that you submit a DMCA multiple times because it's a third-party vendor who vets the copyright infringements for this, and it depends on who you get. And occasionally, if you will continue to issue the DMCA on the content, you'll get someone who actually knows what they're doing. And I know that Will can speak to this as well.
Yeah, I mean, Jennifer, you essentially summed it up. Again, what we do is we sort of have a full suite of services, including not only the documentation and the finding of infringements, but also the removal of infringements. And we deal with Facebook at least on a weekly basis. And there have been, many different types of infringements, even when we do have a successful request that says, yes, we're going to remove this stuff. The stuff's already down. We make sure that the content's actually down. And in many cases, Facebook has a confirmation email sending that, saying that the content has been removed. And our services show that, no, actually it's not. It's still live. You're still infringing. And we have to report listings multiple times. The beauty about that is the more we report, the more evidence we have that Facebook did know about this particular infringement way back, months or sometimes even years ago. And not only did they originally know about it and the content's still up, but we've been reminding them every 2 weeks ever since then. So being able to have that evidence, that really, really makes it a very difficult case for them to defend the fact that, they have safe harbor protections because they didn't know about the infringement and there was nothing that they could do.
Super, thank you. One question that I'm sure we can elaborate on forever. My understanding is that images created by AI, including for book covers, are not covered by copyright. Can you comment on this? And David has a brief answer in the Q&A box, but does anyone want to add anything else?
Sure. I mean, I'll reiterate that answer, and then if Steve wants to elaborate on it. But the Copyright Office has already ruled, according to doctrine, that works created entirely without an AI, meaning no human authorship whatsoever, will be rejected for copyright registration, and that's in keeping with a fairly long history in copyright law. However, that does not mean that works that combine some use of AI and some human authorship may be protectable. It's still evolving law, as you can imagine, and nobody can give you a bright line answer as to how much is enough. However, what has already been established by the Copyright Office is that you can submit a work that is at least in part created with AI, but they ask you to disclaim what was created by AI. The example that was given here, for example, was a book with cover art. This is a common thing that's come up. In fact, it's already been a matter that somebody created a comic book. She wrote the comic book, and that was deemed protectable, but she did not design the artwork herself. She used AI to design the artwork, and the artwork was not registered. We may see some evolving law on this in terms of how elaborate might a prompt be able to get to be so that you could theoretically argue that there's authorship in even artwork that was generated. But as a general answer right now, 100% AI is not protectable. Combination of the two, maybe, but you need to explain to the office what was done by the author, and what was done with the AI. And maybe Steve wants to elaborate on that or correct anything.
No, I think that's very, very good, David. The only thing I would add is to put it in the context that whenever you submit a copyright registration application, the Copyright Office wants to know what is the new authorship that is yours that you're seeking to register. So, for example, if you've written a children's book and you wrote all the text, but you had someone else or you used illustrations from somewhere else and you got permission to use them, so you're not an infringer, but it still doesn't make it your artwork. So in that case, it would be appropriate to indicate on the application, you're going to disclaim the illustrations, but you're registering the text. And it's the same thing with AI. It's just, it was produced by something other than you, the human author.
There actually is a sticky point in the illustration example. If the author of the text hires the illustrator to do the illustrations for the book with the understanding that the author of the text owns the copyright for the book and the illustrations, then it's considered a work for hire, because that is what I spent my career doing, was work for hire. And I did not own the copyrights to the Disney characters or the Warner Brothers characters or the Lucasfilm characters. What I was doing was work for hire. So much of that depends on the contract between the author and the illustrator and the publisher as well.
So thanks for that, Jennifer, the voice of experience there. Absolutely right. And this is one of the examples of how copyright law can be very complex. So I'll go back to my children's book example. If the illustrator and the author of the text got together and agreed from the beginning, let's make a children's book, and I'll write the text and you do the illustrations, then that could very well be a joint authorship where both are considered authors of the entire work. And then you would want to list both of them as joint authors on your registration application. Or you could have a situation where one party hired the other, what Jennifer's talking about, and that's a work for hire. And under the copyright law, exactly as Jennifer just said, even though she's the one who actually made the design, the law engages in this fiction that the movie studio is the author of everything. And the standard for when that applies is written into the law, and it's sometimes controversial. Sometimes it's clear, sometimes it's more controversial. Unfortunately, it's one of those it depends answers.
And on that, unless Jennifer, did you have anything else?
No. My only conclusion for all of this is that AI is a tool, much like a pencil and paper is a tool. And with the case of Qti and RightsClick, AI is a tool for good. And in much of what we're seeing in the press right now, AI is a tool for theft. But put in the right hands, it can be a powerful tool to solve the problem as well.
Great, thank you. And I think Steve may be answering this question in the text box, but can you comment on cookbooks? Can't copyright recipes, but there may be other elements like intro, comments, instructions that might be copyrightable.
Since I couldn't type fast enough, I'll just go ahead and answer it here. Really good question. Right, so in a recipe, you start with the list of ingredients. Those are facts. Facts are not copyrightable. So, a cup of flour or 3 cups of chopped carrots or whatever, facts, 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 not copyrightable. What is copyrightable are the images of the food, the instructions, and you see a lot of recipes these days. It's very common to start with, this is a recipe that my Aunt Cecilia used to cook for us when I was a kid, and all that narration is copyrightable expression, as well as the instructions. Bake until it bubbles up at the corners, what have you. You get the idea. Also, the entirety of a cookbook could be copyrightable as a compilation or a collective work, where the selection and arrangement of the even non-copyrightable elements, in the case of a compilation, is considered creativity in and of itself. In a collective work, both the selection and arrangement and the individual elements may be copyrightable.
Great, thank you. And I do realize we are running up against the top of the hour, but the panelists have agreed to stay on if you would like to continue the conversation. One question for Qti from Anonymous. How does the scam intelligence algorithm detect the difference between infringed work and genuine work?
That is a really, really great question. And the main thing that I'll talk about here is everything goes into the algorithm, whether it be legitimate work, whether it be non-legitimate work, whether it be stolen or authorized resale, stuff like that. Everything goes in. Because again, really what we're trying to do is we're building a profile for a particular brand or for particular product. Where it gets interesting is the actions that we take on a particular piece of work or listing. Every single request that we make to platforms in order to remove content is done by a human being, a person, someone sitting behind a computer that is looking at the data that the algorithm has aggregated and collected and displayed. So what we can do is at that stage, if we see an Amazon listing that our clients have posted, or an Amazon listing that our clients have informed us that that's a legitimate or an authorized reseller, we don't have to perform any action. What we'll do is we call it declining to report a particular listing. Again, all the information is stored, all the the screenshot, all the evidentiary data has been collected. We just don't do any action on that particular listing. We also have ways that our clients can go into a user interface where they can go and they can make a determination on what products they want to see removed, what listings they want to see action against, versus what listings are authorized and they don't want to see action against. So there are different ways to indicate to us the actions that should or should not be taken against a particular listing.
Great, thank you, Will. There is a very broad question about the future of copyright. So if any of the panelists care to comment on where they see copyright heading.
Well, if I can jump in, I think one last question that's been in the Q&A is someone's writing about CMI, Michelle, which I understand. David responded the same way I would have, which is that usually stands for copyright management information. That is information often in the metadata about who is the author of the work, what uses are permitted and what uses are not permitted, for example, those sorts of things that the creator and copyright owner can put into the metadata of a digital work. And the law says, and it's part of the copyright law, if someone removes that information with the goal of furthering copyright infringement, then that's an offense in and of itself, and they may owe the copyright owner or copyright or creator money, damages for doing that, either separate from an infringement or above and beyond the infringement. And Scott Burrows was kind enough to chime in on that as well. Thank you, Scott, and thank you for joining. Turning back to the big, sorry, Jennifer, were you going to say something?
Does that removal include watermarks on photos or signatures off of artwork?
It absolutely can. Yeah, but the catch is you've got to prove that they did it to further the goal of infringement. And that's been the catch on that particular part of the law, because a lot of search engines will automatically strip off all the metadata because they don't want to spend any bandwidth on their server storage on all that extra data, because when you multiply it out by billions and trillions of works, it adds up. Automatically taking it off isn't necessarily an offense, because you've got to be able to prove, like I said, that it was for the purpose of furthering an infringement. So that part of the law it's a good, well-intentioned law. It could use a little tightening, in my personal opinion. So real quick on the future of copyright law. There's a long history. All of copyright law has been a response to technology. All the way back, the very first copyright law in the world in the United Kingdom was a response to the printing press. And you can see the same sort of debates happening over many, many years about things like Xerox machines when they were invented in the 50s to make copies of books. The book publishers back then got really upset. And on and on and on. What we have now is digital technology that allows perfect copies, an internet that allows instant delivery of a limitless number of copies. And now we have AI that will suck up all the copyrighted works that they can find on the internet to build it, and then churn out things that may look just like what they copied in the first place. There's always going to be challenges. The law's always going to struggle to keep up. That's why, at least for RightsClick, and I think for Qti, we want to help creators to do the very best that they can under the rules that are currently in place to respect their rights. We're never going to get piracy and infringement to zero. We just want to make sure that independent creators and small businesses can continue to function in a profitable way and be part of our society. The whole notion of copyright and intellectual property in the Constitution itself is that we will promote more creation, more creativity by letting the creators have a business and make a living from their creativity. Piracy and infringement threaten to undermine that, and that's what we need to prevent.
If I could also comment on that, yeah, Steve, that was a great response. I would also say that something that both RightsClick and Qti bring to the table is obviously technology, and I think Jennifer mentioned how artificial intelligence is like a tool, and it can be used for good and bad. You can go out and you can search and document all the listings that may infringe on your work, but that will be all consuming. You will have no time to be able to go and actually do what you want to do, which is, continue to be creative, continue to work on your craft and stuff like that. But you could, you could do that. That's where we come in and we can do that documentation process. The same way as you can go and you can apply for your own copyrights at the Copyright Office, the U.S. Copyright Office. It will be difficult. It will be confusing. The platform and the forms and everything that is confusing, outdated. Before we even opened up the webinar, we were talking about how outdated everything is. That's where RightsClick comes in, where it sort of masquerades the confusion and allows for this very, very intuitive, very up-to-date platform, which makes it just so incredibly easy for consumers to protect their work, just as TurboTax is able to make it easy to file your taxes. RightsClick makes it easy to file your copyright. And as long as we are able to provide these types of solutions, I think that we're going to be able to keep up with the problem of ongoing infringement, because just like Steve said, unfortunately, there will always be piracy, there will always be infringement, but being able to use technology and keep technology at least, at the same level as some of the infringers, we'll be able to be proactive about hopefully keeping the problem mostly under control for brands and independent artists.
I'll only add to the broad question, what is the future of copyright? I'll say that I think it's bright, because 10 years ago I jumped into this, what they call a copyright war, as an advocate, not as any kind of expert in the law whatsoever, but as an advocate, as a creator who believed in artists' rights. And one of the more dismaying aspects of that war was to watch creators themselves believe that copyright was somehow outdated and not important anymore, and that the internet industry had kind of obviated the need for copyright. And this was certainly the message that Silicon Valley was pitching, and they're still pitching. However, they have lost a lot of ground on that argument for a variety of reasons, AI being a big one. The advent of generative AI, as distinguished from the kind of tools that Will and Jen were talking about a moment ago. Generative AI has brought artists, to the foreground, suddenly very animated over defending their rights. and for good reason. And we've seen people who, even specific individuals I could cite, who a few years ago were very skeptical on the idea that copyright was important. Now suddenly that everything is being scooped into this machine without their permission. Now they're suddenly realizing, yes, it is important. So that's, I think, positive, and frankly, what I see even among lawmakers remains generally positive on the importance of copyright. We don't see a lot of bipartisanship these days, but one place you do see it is in places like IP subcommittees, talking about the importance of artists and how important businesses like Jen's are to the American economy. And so I would not by any means write off copyright anytime soon.
Thank you, David. To the panelists, any final thoughts? Okay.
Thank you all for making my life much easier.
Oh, it's very kind, Jennifer. Yeah, I mean, I think in conclusion, Qti and RightsClick have really just been designed to bridge that gap between the accelerating speed of technology and the lag of the law. So we'd be happy to continue the conversation about how we can help you as an independent brand. We look forward to hearing from you, and the session will be available on both RightsClick.com as well as Qti.ai over the next couple of days. And we hope that you enjoy the rest of your day.